All right, it is time for the legal lowdown with Attwood Martial Lawyers. After someone passes away, families are often dealing with a lot, everything from grief and funeral arrangements to managing finances and practical matters. But at some point, a question usually surfaces: when will the estate be distributed? And when will beneficiaries receive their inheritance? In many cases, beneficiaries expect assets to be distributed straight away, and especially if there's a will clearly saying who gets what, but it's not usually the reality. There are legal risks, there are waiting periods, and there are administrative steps that must be followed. And distributing too early can actually expose an executor to personal liability. Joining us today from Attwood Martial Lawyers is Estate Litigation Senior Associate Duncan MacDougall. Duncan, thanks so much for joining us on Afternoons.
Thanks for having me again.
It's hard to imagine that these sort of questions are being asked when, for want of other phrase, the body is still warm, you know? I can't believe that this happens.
That's it. Yeah. Well, a lot of executors get a lot of pressure from beneficiaries. All of a sudden, when somebody passes away, people start seeing dollar signs.
Yeah.
And they want their money quickly. I guess the economy at the moment as well, just people are pinching pennies. So it's wanting to get that inheritance as soon as they can. But also the executor has a number of different duties whilst administrating the estate to make sure that they comply with before that distribution takes place.
Okay, so typically what needs to happen, I guess, before an executor can distribute the assets to beneficiaries?
Yeah, so there's several different things that the executor ought to ensure. One is we got to find a will. Is there even a will? Is it valid? All these sorts of questions about the actual will itself. Is a grant of probate needed in this instance? So certain financial institutions, banks particularly, won't release funds over a certain threshold, usually around that 30 to 50,000, without a court stamp of approval saying, yep, that's a valid will. Yep, that's an entitled person to administer the estate. That's a bit of a long process as well to get that grant from the Supreme Court. Once they have that in hand, liaising with all the asset holders, banks, share registries, dealing with the titles office in respect of a property, determining all liabilities, making sure they're accounted for first, because all liabilities and debts have to be paid off before distribution takes place, making sure all sorts of taxation affairs are taken into account, and then notifying everybody in terms of what their rights are in relation to the estate. So there's a multitude of different things that they have to deal with during the course of the administration, and it's not an easy job, and that's why most executors ought to get some legal advice to make sure they're complying and checking things off the list.
It sounds like there's a lot of T's that needs to be crosses and I's that need to be dotted.
That's it.
Before that can happen. I guess then, is there a general time frame that executors are expected to follow when administering an estate, or is it just case by case?
Yeah, there's a thing what's called an executor's year, which is more so a practical benchmark in terms of an executor trying to wrap up an estate. But that's all given on the circumstances as well. It might be a very complicated estate, multiple properties. There could be claims on foot as well, which will delay the extent of the administration and whilst they're dealing with and responding to those claims. But there's also statutory limitations as well. So, for example, when somebody makes a family provision claim, an executor ought not to distribute an estate before 6 months, because it's within that time a claim can come forward, or at least notice of a claim can come forward. And then they've got 9 months from the date of death to actually make a claim as well. So generally speaking, at the very least, it's not going to be distributed within those 6 months.
Right. Okay. So if you're looking at a windfall, a cash windfall, if you've got a great Aunt Irma or whatever that's passed away and you think you're seeing dollar signs, you've got to wait some time as well.
Yeah.
If you've got a question as well that you would like to ask Duncan, please feel free to text through 0499 880 882. You can email us as well, afternoons@4bc.com.au, or you can call us as well on the 4BC open line, thanks to Watch Smoke Alarms, 133 882. We're talking about inheritance and distribution from an estate, and early distribution as well. How often do you see this happen where someone, wants to have their portion of the will or whatever distributed to them early?
Yeah, and a lot of times that's what the executors are faced with from the beneficiaries. There's this exert pressure from them saying, give me my money now. I deserve my money. I'm entitled to my money.
Yeah.
But at the same time, if they're distributing too early, the executor, there's some personal liability that can come back on them, provided that, for example, maybe a creditor emerges at the last minute, provided a claim, some sort of, maybe it's a stepchild or some child that's hasn't been in contact with the family for some time, makes a
Sure.
claim at the last minute. All of a sudden, the estate has already been distributed. The executor could potentially be personally liable to recoup those, because it's not very practical, or it doesn't make sense for them to claw back a distribution already made to beneficiaries, because once beneficiaries receive their inheritance, it's my money. I can do with what I want with it. Good luck getting that back.
Yeah, right.
That's where there's a lot of liability that comes with that, and it's important that they're across it.
Here's a question. It's a personal one. What happens if someone passes, they've not left a will, but they've left a mountain of debt that we didn't know about? Are you personally liable for it if you're not, like, none of us was an executor, none of us knew that it was going to happen and happen quickly and there was no will?
Yeah.
Are you personally liable as a next of kin or someone that was related to them?
No. In this instance, those debts are be paid by the estate, potentially, depending on what the extent of those assets are. So that is also a lot of delay in terms of the actual administration of the estate, is identifying all those assets.
Sure. No assets.
Well, no assets, and there's only debt.
Nothing.
Then it
Only
could very
debt.
well be the estate is insolvent, in which case then you get a trustee in bankruptcy, and it's almost operates very similar to when an individual goes bankrupt.
Sure. Okay.
So
just that individual has passed.
Exactly.
Okay.
Yeah. So there's no liability that falls back on an executor in that instance.
That's what I always thought. And even if you were an executor, are you not then held personally liable as well?
That's right. Yeah.
Okay.
Yeah. As long as you're administrating the estate properly. And even so, even an executor, if, for instance, they're contributing funds during the course of the administration, paying off for these immediate things themselves, they're able to get that reimbursed to them for those expenses that they may incurred personally whilst dealing with the administration of the estate.
Right. If there was anything of value left behind, which
exactly.
there was not.
Which could very well be the case. And that's sometimes we see estates where they are insolvent and there's no assets to deal with, in which case you're dealing with bankruptcy.
Yeah, okay. Well, that's exactly what's happened. But there's always that question mark over, am I going to be held personally liable? Is someone going to be coming up after me because of the debts that they left behind?
Yeah, no.
And as family members, we sort of like, are we prepared for this? Because we ain't got no savings.
Well, that's even goes in terms of the estate planning aspect as well. That's why during the course of preparing somebody's will, it's very important to understand what's the extent of your assets, what's the extent of your liabilities.
Yeah.
Is there even an estate to distribute? Even if you have a certain plan under your will to distribute certain assets and certain values to certain individuals, do you even have the cash at this time to even make those distributions?
Yeah.
So it's important to make sure, and even in taking into consideration what's 5-10 years going to look like. That's why it's important to have these conversations every 3 to 5 years to make sure you're across what your estate currently consists of.
Really? So even when you're thinking about drawing up a will, you've got to factor in, obviously, a mortgage is a mortgage, and if that asset was to be sold, whatever money the bank is not owed is cash, right? I understand that. But it reminds me of the time when my husband proposed, and I said, "Are you sure you want to do this? There's something I need to tell you." And he was thinking the worst, that I had a side piece or something. And I said, "No, I have far more debt than I lead on, because at the time our finances were separate." And I said, "I'm working through this personal debt that I racked up living large in my 20s." And you don't even think of the practicalities of that. He just thought, "Oh, that's fine. I'm going to help you go through that." But even when you write a will, you have to think about those things too, those things that are in the background.
And especially a lot of times people want to do wills themselves. But if they're in a relationship, it's important to understand, I suppose, how things are going to be tied up with one another, how certain assets are owned, whether they're joint tenants in common. Somebody's got some sort of liability there. Somebody's creditor in some way. Maybe you've got some sort of loan agreements with one another, etc. So definitely when you're getting your estate planning done, especially if you are in a relationship, get it done together so you're both aware of what the, I guess, liabilities and risks are to one another if one or both of you pass away together.
My guest right now, as he joins us most weeks on a Wednesday at this time, Estate Litigation Senior Associate Duncan MacDougall from Attwood Marshall Lawyers. The text line 0499 880 882. Helen has texted in and has asked if a solicitor pays out money from the estate due to pressure before all bills are paid. Are they responsible for those expenses?
Well, you're taking instructions from an executor in that instance. So unless this solicitor is also the executor under that will.
Would that ever be the case?
Could potentially be the case. Some people just don't have a next of kin or any sort of other family member. So they choose, for instance, a trusted friend or even an advisor in this case, a lawyer, to administer the estate. in which case they ought to know better in that instance. They would not likely have done that. But again, who knows? It could very well happen. But even if they did, then yes, there could potentially be some personal liability there, particularly if there's some debts that have arose or some sort of creditor has come out from the woodworks and there's no money left.
Yeah, right. That's interesting. But yeah, you would think that a solicitor, if they were chosen as executor, they would not go down that path.
This is why you reach out to them, because they'll know the ins and outs and the roles and duties and of acting in that role as an executor.
All right. Okay. I hope that answers your question, Helen. I think it would make sense if you're in that profession and you do that and you jump the gun and then you pay out. I guess, what are some of the common things that can delay estate administration in a way that would make people who are beneficiaries frustrated with how it was all supposed to pan out?
Yeah, so there's multitude of different things with that. I think a lot of times people don't understand the extent of getting probate as well. Generally, there's a 10-week period there at the very minimum in order to get that process and get that grant. Once that golden ticket is in hand, then that'll assist the executor to administer the estate. A lot of times it's valuing and identifying certain assets. So a lot of people don't know what they own, unfortunately. Right. So
it's just stuff.
It's just stuff, and it's tied up in trusts, etc. Superannuation they may not even be aware of, things like this. So especially when you got an executor who may not know the ins and outs of somebody's estate, a lot of it's a fishing expedition at the very beginning to try to identify everything.
Right.
Because as part of those duties, you have to call in everything. And again, banks, financial institutions, superannuation funds are not the most speedy bunch either. So there could be some delays there in terms of actually calling in certain assets.
Right.
And family disputes and any sorts of claims, whether that be the claims on the validity of the will itself or these family provision claims where, hey, I've been left out. What can I do?
These can take time. Yeah. It's sort of a bit like how long is a piece of string?
Absolutely.
All right. And very quickly, any advice for someone who, I guess, who's an executor who might be feeling pressure to distribute, to beneficiaries quickly?
Yeah, and in that respect, I think just get that advice early. Don't rush it. Make sure those T's and C's are accounted for.
Otherwise, you could be held personally liable.
Exactly, absolutely. And just, I think, transparent and open communication with beneficiaries, give them a realistic outcome as well, because a lot of beneficiaries come to us as well and say, well, I'm in the dark. I don't know what's happening. I don't know what's transpired during the course of the administration. I don't even know the extent of the administration or even the extent of the estate. So the more disclosure that they provide to the beneficiaries in terms of timelines, what's in the estate, etc., the more, I suppose, realistic that they'll be in terms of understanding when they'll be receiving these funds.
Yeah, and eliminate all that heartache, hopefully, in the process.
You bet.
Very quickly, just had a text through. I had an executor steal $500,000 of my wife's estate, cashed the check into her own bank and spent it. And in that case...
That sounds like somebody who didn't get appropriate legal advice, because those funds ought to go into a trust account. Right. Generally, people use a solicitor's trust account when calling in those funds, or they'll go to the bank and open up an estate account. But when they use their own personal account, that's a no-no. And all of a sudden, that's, again,
you're personally liable. And it seems like quite a criminal action.
Yeah, well, yeah, dodgy things there.
Duncan, thank you so much for joining us for the Legal Lowdown. I'm sure we'll see you next week.
See you then.